Yeah.
Call our next case, Bellmore versus Friendly Oil Change.
Good, Richard? Okay, got it.
Good afternoon. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive, and if you are going to reserve time for rebuttal, we ask that you keep track of your time unless we use it all up. So, and you may begin when you're ready.
Thank you. Good afternoon, everyone. My name is Jonathan Green. I represent the appellate, Karen Bellmore. The court has listed 2 questions to discuss. Oh, I should reserve 3 minutes, excuse me, for rebuttal. The first is whether or not the injuries that she suffered arose out of the maintenance of the vehicle as a motor vehicle. The trial court agreed with me that they did. Where I think this kind of went off the rails is at the Court of Appeals. One of the things that the Court of Appeals argued was that it wasn't a direct result. And that is not the standard. The standard is whether, is that it has to be more than just fortuitous, but for, and specifically, incidental. And those cases that use the term direct are not using it in a manner to connect liability, but rather to describe what happened. The standard is, again, whether it's more than incidental, fortuitous, or but for. The whole point of an oil change facility, the whole point of its existence is it has that special tool there. It has the oil change pit. And to say that it is incidental belies the fact that it is central. To say that it was fortuitous, there was nothing fortuitous about this. This was the #1 safety concern, and as standard of the industry, you don't let people in and around the oil change pits. She wasn't there per happenstance. She wasn't there to get some change out of her car to go use a candy machine. She was actively involved in the servicing of the vehicle, which isn't even required under case law. We have the case, for example, where the radiator.
That was going to be my first line of questions here. So you mentioned she wasn't trying to get something out of her car. You know, she didn't approach the vehicle on her own without being pulled over. If she had, would we still be here having this conversation?
Yeah, under these circumstances, I suppose it's a case-by-case examination according to the case law here. We have to look at each individual case, but just for argument's sake, let's say she decided, I need to go and get something out of my car, okay? I think the argument still remains because none of this would have happened had the car not been over that service pit.
But is that the test? So any type of maintenance that's being conducted on a vehicle, the entire premises, anything that happens there, that if she is even tangentially related, then it's due to the maintenance of the vehicle?
Well, in this circumstance, if she had slipped and fallen in the corner on her way to get something out of her car, I think arguably that has nothing to do with the service. The injury, it was too attenuated. But had she been on her way to get get something out of her car and hot coolant spewed out of it.
That's different though. That's
right.
Different than the pit.
Okay.
So
But the pit is the tool. The pit, and we can't ignore the fact that you need the pit to do the job. It's no different than a wrench or a jack or a lift. And that also would take us to that second issue of parked vehicle exclusions.
Wait, before you get there, so I just want to be clear. Is your position that it does not matter whether she was directed to look at the air filter as part of the maintenance or not, that she could have just been getting a stick of gum out of the car and it would have been the same outcome?
I think it does matter because we look at it on a case-by-case basis. And I don't know if we can have a bright line rule here, but in this particular
Well,
circumstance,
that's kind of the only reason you're in our court, because we're searching to see if we can bring some clarity so the lower courts will know where to draw the line. So if we can't draw a bright line rule, maybe,
Your Honor, if I was going to draw a bright line rule, under these circumstances, if you are injured because you fall into the service pit while your car is over the service pit being serviced, under
even
those
if
circumstances.
you were neither conducting the maintenance or involved in the maintenance in some way.
I think that's a pretty fair statement,
Why are
because
you-
you're not in there for
Just
happenstance.
as a curiosity, you're not happy to win your case? You have to try to win other people's cases?
I'm
Why
happy to
don't
win
you
my
argue your
case, but the Court of Appeals took it away from me.
I know, but why are you arguing for more than your case, the
Well,
facts in your case? Why are you trying to help other people? You know, you should focus, you have a pretty good fact there, that your client was directed to look at the
Yes.
air filter over the pit.
And I agree, and, you know, I certainly don't mean to argue the other side's position.
Going
but-
back to the bright line rule.
I don't mean the other side, I mean other cases that aren't before
Yeah,
us.
the extensions of the facts of what happened.
Right.
here. But what you put forward as a bright line rule, that's not really a bright line rule. I mean, that's an application to the facts of your
Yes.
case. So when we're looking at what that term maintenance means, I mean, that's what we're here talking about. We're trying to give direction to the lower courts and to attorneys and to people that are potentially in this situation of when they may have a case that, you know, that rises to the level of, and, you know, may result in them getting compensation, right?
Right.
And getting recourse.
And I think in this case, the use of the service pit is central. And that service pit is a tool.
So here's a question for you. I'm at a garage that does oil changes. And it's clear that they do oil changes in several different bays. And I get called over to look at something, and I slip on, and I'm 3 bays away is where my car is, and I slip on some oil in another bay that I'm walking through instead of walking around. Is that part of the maintenance of my vehicle that's there?
You see, and now it's a different factual situation
Yeah.
from what we've got, but I mean, I would say that in that circumstance, you were called over to look at something for your car. You are injured by a tool in that shop. Had you slipped and fallen and just landed on the ground, it might have been a different situation. But the pit is the key here. That's the tool. I think it would be
Does
no
it have to be
different.
the tool that's being used for the maintenance of your specific vehicle? What if I fell into the pit next to the pit that my car's over?
I think it's part and parcel of the situation there, because if there was, again, these are tools that are being used for purposes of maintenance of the vehicle. The problem is, again, it's such a case-by-case basis, but I think for our purposes here, if we're looking at what happened, the use of a tool, you're involved with the situation, and you're injured as a result of it. And, you know, I don't want to, I guess, run from the question here, because it's a difficult one.
Well, it is difficult, and I think that's why we're giving you some other scenarios, and I appreciate that you're, you know, trying to stay true to the facts of what happened here with your client, but I think it might matter if you get called over. If you're just gonna go to your car,
Right.
you know, to get a stick of gum, you know, you shouldn't, you know, maybe you shouldn't be over there to begin with. That's why you go somewhere else while the car's being serviced. So
And-
we're asking kind of like the edges around this, because we're trying to get an understanding of what maintenance means and what maintenance of your vehicle means and how close you have to be in what situations.
Well, I think that maintenance is a global term because it involves a number of things. If you're doing an oil change, for example, you know, it's not just, you know, press one button and it's done. You have to have the vehicle over a pit, or you have to have it on a lift. You have to make sure that you have the tools. You have to make sure that you have a receptacle for the oil. There are all these things that are involved that are part and parcel of the maintenance, okay? I would think that, here would be another interesting episode. What happens if somebody undoes the oil drain plug and the oil spills on the ground and they slip and fall on the oil, okay? Even if they're on their way to get a candy bar, okay, I think maybe in that circumstance you would find that it arose out of the maintenance because it's no different really than when the
You're going
steam
to get
escapes.
Justice Viviano asking you the same question again while you're arguing other cases. You just went like 3 steps past.
It's because, and this is where it gets very difficult here.
So I'll circle back to what bright line rule are you asking us to adopt here? And it can't be just a rule that applies to your specific case, because we don't do that, right? This court tries very, very hard to not just do error correction.
Right, and unfortunately, we're in a difficult position because I think they have taken it out. I think the Court of Appeals took it out when they said it has to be directly caused. They put a different standard on there. They also put a negligence standard on there where they said, well, it was her fault for not watching where she was going. This is a no-fault claim. So the brightest line I can tell you is if you are injured and it arises out of the operation and maintenance of a vehicle, and maintenance includes everything start to finish and everything associated with that maintenance, then that has to satisfy the statute. And I think part of the reason that we talked about the parked vehicle is even if it's not arising out of the maintenance, the vehicle was parked in a manner so as to cause injury.
Did Miller correctly define how the word park is used in the No Fault Act?
I think that to the extent they're talking about, yes, to the extent that, look, you can't do maintenance if the thing isn't parked.
That's not the question.
I'm sorry?
That's not the question. Did Miller correctly define what it means to be parked under the Act? I don't know if you've read my dissent in a prior order, but I don't like the way Miller handled that, and I'm asking whether you agree or disagree.
I think that I agree with Miller because those exceptions, they emphasize the status of the vehicle as a motor vehicle overall. So that's the best I can answer with that, Your Honor. I will reserve the balance of my time. Thank you.
Thank you.
Good afternoon, Your Honors. Jamie Woolard on behalf of the Appalachia State Farm. I will start off addressing a few of the issues that just came up in the last few minutes. First of all, I think the suggestion that the bright line rule means that maintenance should encompass everything from start to finish and everything associated with it runs the clear risk of ending up in a situation like you brought up at the start, Justice Clement, of sort of everything in the garage, everything around it. If there's anything tangentially related to the maintenance that's on the site, if that's involved, if that has some involvement in the plaintiff's injury, then the injury arises out of the maintenance of the vehicle. And I think that's just clearly far too broad a standard. A point I'd like to make that didn't come up yet is that I think it's important that at the moment of the plaintiff's injury here, the record reflects that there wasn't any maintenance actually being performed at that moment. What you had was a mechanic who said, you have to change this particular filter because it's dirty. Come here if you want to take a look. But there's no taking the filter out, there's no unscrewing the filter cap, there's no changing the filter, there's no actual maintenance happening, and the pit, which Brother Counsel said is central to the analysis here, the pit isn't actually even being used at that moment for anything. The car is sitting over it, yes, but there's nothing in the record showing there's any maintenance happening in the pit. What's happening is people are standing above the pit,
That's a pretty
trying to look at something.
myopic view of maintenance, isn't it? So you're saying when I drive into the oil change shop and from the point at which I turn over my car until the time I get it back, it's not undergoing maintenance?
Sure, but the injury has to arise from the maintenance. So if we're going to say, as soon as I pull in until I leave, any injury, I mean, I think the alternative is say any injury that I might sustain in that shop
Well, here
arises from the maintenance because
I mean,
my car's being
I
maintained.
don't disagree with you there to some degree, but here the plaintiff was directed to look at the car to authorize part of the maintenance. Isn't that part of the maintenance process?
Well, I think the Court of Appeals correctly found there was nothing about that that actually caused the plaintiff to fall into the pit. I mean, the plaintiff walked up to the car and walked straight into the pit, even though it was well marked with bright yellow paint around the outside of it, and even though she had
But
testified that she knew it was there.
We're not doing at this point, I don't think, like a negligence or a fault-based assessment of why she fell in the pit, are we?
No, and I don't think it actually goes to negligence. It goes to causation. It goes to whether the maintenance actually gave rise to the injury or whether the injury was due to something else.
The pit here was not unrelated to the maintenance, was it?
No, it wasn't unrelated, but the standard, again, isn't related to the maintenance, and I think, I mean, not to get far afield, but if we look at...
We have cases where somebody falls on a patch of ice, for example, that's not necessarily caused by the maintenance. I'm struggling with the idea of why, as counsel suggests, why we should treat the pit as anything different or as different than, a hydraulic lift or a jack, things that are designed to allow a service person to gain access to the undercarriage of the vehicle. That's all a pit is, right? It's another way of allowing the service professional to gain access to the undercarriage, right?
Sure, but I think, let's take, for example, a hydraulic lift, and here we're just speaking hypothetically, right, because there wasn't one in this case. What could cause, what about a hydraulic lift could we imagine might cause an injury? Well, let's say a malfunction.
Let's make an obvious one. Car's
Okay.
up on the lift, the mechanic says, here, come here, I gotta show you what's wrong with your something or other, your engine or your oil pan or something, and you say, oh, yeah, it looks like there's a spot there, and then the car falls off the thing and falls on top of the person.
Okay, well,
Is there coverage or no?
Well, there you've got, I would say likely yes, because there you've got an instance where you've got the vehicle itself is, I mean, clearly the injuries, the vehicle itself is the instrumentality of the injury, right? I mean, the vehicle's falling on the person. It's not unlike in the McMullen, or sorry, not the, yeah, I believe it's the McMullen case with the.
I'm not an
car and
expert
the
on
jack stands,
Uncle Ed's oil shops, but presumably they have these pits so that vehicles don't fall on people, right?
I would imagine so, right. But I mean, I guess I would also distinguish something like jack stands or a lift from a pit in that the pit's not doing anything. It's just a hole in the floor. It's just there. There's no way for a pit to malfunction. There's no way for something to fall off a pit. It's a void. It's a space. Is it a means of gaining access to the underside of the car? Sure. Is it related to the plaintiff's injury here? Well, obviously yes, because she fell into it. Was the maintenance, I mean, the issue isn't is the pit related or did her injury arise out of the pit? Did it arise from the maintenance?
I mean, it sounds like it's like a shell game here. The pit's related to the maintenance, and the maintenance is related to the injury. Or let's see. Yeah, the pit's related to the injury.
Yeah, and so then we've got, I
But
think,
now you're saying the third.
a connection that's too attenuated, I think.
What are we to make of, I think most of these facilities do have policies like, that existed in this case, that we don't want people walking around these areas for precisely the reason that what
Sure.
happened here could happen. What do we do with that?
I mean, I think that's potentially a basis for a negligence claim that the plaintiff might have against the oil change shop for, it sounds like letting her into the service area, but and she did bring a negligence claim alongside the no fault claim, but.
Sure, but it does go to some element of foreseeability here, doesn't it?
I mean, if you're in the area, is it foreseeable that you're going to walk straight into a pit? I mean, I suppose it is relevant to that, but how much weight it gets, I think very little, because as the record shows and as we explained in our brief, She testified she'd been there multiple times before, knew that there were these pits in the floor, knew that the car went over the pit in order to be serviced, saw the bright yellow lines or marking, wide yellow marking around the pit as she walked up to her car. So I think, and that gets to the standard from the Stewart case, I think, about, and this is skipping, I think, more to the, was the vehicle parked and does 3106 apply? But I think it's important that, this was the pit was a hazard that was readily observable and easily avoidable.
But wouldn't lying under a car also fit that? I mean, we didn't look at the fault of the plaintiff or the knowledge that, like, hey, look if you're gonna lay on your back underneath a car could fall on you, right? We didn't look at his faults or the sort of, wisdom of him doing that activity, right? To determine this question of whether or not it rose out of the maintenance of a vehicle, as a motor vehicle.
Right, I'm sorry, I was just addressing the, what relevance the fact that she was apparently allowed into the service area of the facility, what that might have, or what I made of that. No, I don't think fault's an issue here, and we haven't argued that fault is an issue.
Well, but the Court of Appeals sort of incorporated that into their analysis of why it didn't fall under the maintenance provision.
I think the Court of Appeals was careful to, and I mean, we could look at it again, but I think they were careful to explain they were talking about causation and not about fault. They weren't saying, well, she was responsible for her injury, therefore she can't recover. I think they were explaining that the maintenance did not cause the injury. What caused the injury was, in this case, her admitted failure to look where she was going and then walk into the pit, despite seeing the yellow markings around it. So I think that does go to the issue of causation, and whether it's the same issue or a related issue, the issue of whether the injury arose from the maintenance. It's difficult for it to arise from the maintenance in that case when there's no, I mean, if you look at really, I think all of the other cases that both sides have cited on this question of when the injury arises from the maintenance, in all but one, you've got a plaintiff who's actually performing the maintenance when they're hurt, when they slip or whatever, right? So then it's pretty clearly arising out of the maintenance because they're hurt while they're in the act of maintaining the car, spraying it with a car wash wand or trying to change the shock absorbers. And then there's the one case, that one, where the guys, sorry, not that case, it's the McMullen case that involves somebody not performing the maintenance themselves, but passing by the car while maintenance is being performed. But that's one where the car, again, is the instrumentality of the injury. I mean, there's a radiator cap taken off, there's steam that comes directly out of the car and hits the plaintiff. There's just nothing like that here. There's nothing that arises from an act of maintenance by somebody at the oil change shop or that comes from the car itself and injures the plaintiff. It's the plaintiff, there's a passive hole that she walks into.
Why isn't the fact that the plaintiff was directed to look at the vehicle while it was over the pit, why isn't that exactly what you're talking about? Why doesn't that fit?
Because there's no maintenance happening, that needs to be changed. You can come see for yourself, but there's no equivalent of.
Wasn't the question, we think it needs to be changed, but we need you to approve it, so come and take a look at it so we can continue working on your car.
I don't think the record reflects that that the mechanic asked for her approval. I think the testimony just reflected that. He said,
why else look at it?
Sorry?
Why else look at it?
To show that it actually does need to be changed. I'm not just making it up,
To
perhaps.
show that it actually does need to be changed, wouldn't that arise out of then the maintenance of changing it?
I mean, not if nothing's happening to the car, which nothing was happening. There was no maintenance happening at the
The
moment.
But it's the arising out of.
The example, sorry, to just piggyback on that, the example you gave about the car being lifted up and saying, come over, look under here, or
Sure.
maybe just as Fabiano did, and the car falls on you, there's no, maintenance going on at that point in time. So what's the distinction there? Because you said if that were the case and the car were to fall.
Sure, I think there, among other things, I mean, the car is the instrumentality of the injury, right?
So it's separate than the maintenance.
Sorry?
It doesn't matter if there's maintenance going on in that situation or not.
I suppose there's an act of maintenance in putting the car on the lift, raising the lift, and it's clearly in that scenario positioned in a way that's not correct because it shouldn't fall off the lift. So there's either a defect in the lift or a problem with how it was raised up or a problem with how it was placed on the lift. But here there's no act that actually happened that injures the plaintiff. It's just simply the plaintiff tragically walking into the hole. I mean, I think I don't think that it's black and white, that there's a sort of, you can say this set of things amounts to arising out of and this set of things doesn't. I mean, there's obviously a spectrum, right? And I think the courts, this court and the Court of Appeals have recognized that in the opinions that that are raised in the briefs. Talking about, attenuation, is the connection too attenuated, or is the connection a tight one? For example, I mean, we discussed in our brief the Willer case, where this court decided, even somebody engaging in an act of arguably what would be maintenance, scraping the car windshield and then slipping on the ice, the relationship between the injury she sustained and the maintenance was too attenuated. It doesn't mean there was no relationship, but it was simply too attenuated to be considered to arise out of the maintenance.
Did the Court of Appeals just misunderstand the relationship between 3105 and 3106? I mean, once it concludes that the plaintiff's injuries didn't arise out of the maintenance of her vehicle, why is it going on to look at 3106 to see if the claim could survive the parked vehicle exclusion?
I'm actually not sure why the Court of Appeals did that. I mean, I think we even said in our brief that at that point they didn't need to address whether the car was parked or not once they decided that the injury didn't arise out of the maintenance.
So you don't think both have to be satisfied for the plaintiff to make a case, do you?
Well,
I
that's
mean,
a
just
big
to be
question.
clear, that's not what I was suggesting. I think
Okay.
if it is a parked vehicle, if it meets whatever the correct definition of a parked vehicle, then it would have to be satisfied for there to be coverage. But if the court concludes under 3105, the general provision that doesn't arise out of maintenance, the claim is dead, right? It doesn't have to fail for another reason, too.
Right, no, exactly, I agree with you. And I'm not sure why it then went on to 3106. I mean,
In other words, 3106, the exceptions to the exclusion, parked vehicle exclusion in 3106, don't create a separate basis for liability. It's just 3106 is explaining which parked vehicle claims can continue to exist under 3105, even though the vehicle was parked.
I think that's correct, Your Honor.
Okay, that's.
I mean, I think, and, if we can discuss it if you like, I mean, I think that, the parked vehicle exclusion would apply here to preclude the claim, or should apply here to preclude the claim. I know there's the issue of the Miller decision and sort of to what extent that's been
Briefly, because you're out
cabined
of
in that.
time, tell me why, or tell us why.
I mean, I think the plain language of the statute says, of 3106, accidental bodily injury does not arise out of, in this case, the maintenance of a motor vehicle as a motor vehicle. I think it can't get any clearer than that, unless one of those three exceptions applies. I think the issue is that, after Miller, I mean, at least.
Is it the issue here, the Court of Appeals, it's very, sort of, they weren't very careful in their analysis.
I-
They appear to be concluding that the plaintiff didn't satisfy 31061A. The vehicle was parked in such a way as to cause unreasonable risk of the bodily injury which occurred. Am I understanding its decision correctly?
I mean, the way I read it was, I think so, but the way, and I was a little confused by this as well. The way I read it was that the Court of Appeals was first saying that the car isn't parked, which I think, Brother Counsel and I think we agree it was in fact parked. But I think that's where things started to get confusing, when it says, well, it's not parked, and then she didn't establish that an exception applies. So I have to admit, I didn't quite understand the logic of how that worked. I mean, I think the vehicle was parked, and she did not establish that one of the exceptions applies. And I think that should preclude the claim. But again, I think what's in the background there is what effect Miller has, and whether it's the case that if you're doing any kind of maintenance on a parked vehicle, despite the plain language of 3106, 3106 just doesn't apply. You just ignore it, and you only look at 3105. I don't think that's correct, but I recognize that's not my decision to make, so.
All right, thank you, counsel.
Thank you.
Very much.
Thank you. Just a brief reply. I do think that the Court of Appeals, I think, made this a little more difficult than it needed to be with the idea of parked versus positioned, simply because I think there's a universally understood definition of parked, or at the very least assumed, which is a common sense definition. You cannot perform maintenance on a vehicle that's moving. And where I think, and just, to make sure that everything is clear on this, my position on the whole parked vehicle exclusion was that it is an addition. I think it is an expansion of those, not just an expansion, but an explanation of how a parked vehicle can have injuries in situations where no fault benefits are available. And in this particular instance, they specifically directed the driver of the vehicle to park that vehicle, to place it, whatever language you want to use, to leave a 2-foot gap in the front of the vehicle over that pit. So they created a dangerous condition, and it is exactly the sort of injury that is to be expected by placing the vehicle like that. So where we talk about parking the vehicle in such a way as to create or cause injury under 3106, I think that's the definition. Thank you.
Thank you. Thank you both. The case will be submitted.